Ladies and gentlemen, welcome back to the IndieZoNe. My name is Kathy. If you have been following the Idaho versus Kohberger case, then you know that there have been so many legal issues and so many battles between the parties, the state of Idaho and the defense. They've agreed on very few things. And in many cases, the battles over whatever the particular legal issue is were waged over periods of many months. Take, for example, the issue of change of venue. That took a total of 9 months to finally resolve. Mr. Kohberger first filed a motion seeking a court order to change a venue of the case from Latah County, which is where it originated. That's the county where the crimes occurred. But Mr. Kohberger felt that a change of venue was necessary, believing he could not obtain a fair trial in Latah County. And the state of Idaho did not want the matter moved. They fought against it. They fought hard to keep the case in Latah County, but in the end, as you know, the defense won that battle. The case was moved in September of 2024, so it took from January 2024 all the way through September, and in between, many papers flew back and forth. There were many hearings, so many hotly contested issues before that matter was finally resolved. And because change of venue happened, the case is now before Judge Stephen J. Hippler in Ada County. I would argue that the issue of change of venue paled in comparison to another matter that seemed to be even more hotly contested. If you look at the court records, which we do at this channel, we focus on the court filings, and we urge you to do as the jury will do. Look at what will be admitted into evidence and what will not be. That's the subject of all of these motions in limine that have been flying back and forth over the past several weeks and the responses to them. The topic of IgG evidence, the DNA, the testing of it that related to the sheath that was found at the crime scene, specifically on Madison Mogen's bed, where she and Kaylee were found, has been the subject of so much hotly contested issues, so many battles. There have been hearings, there have been papers flying back and forth. There have been protective orders that have been rendered in the case. Well, we see a very rare agreement between the two sides on a legal issue. And of all things, after all of the battles over IgG, this agreement is, guess what? Over IgG. And what the future jury will be able to know or not know regarding IgG DNA testing. We know this by looking at a March 17th, 2025 document. It is a defense filing. It is the defendant's reply to state's opposition to motion in limine, number 11, regarding excluding IgG evidence. Now, this is an early reply. If you've been listening to some of our recent episodes of the IndieZoNe, both the podcast and here on YouTube, you know that the 24th of March is promising to be a very big day in the case, because that's where the vast preponderance of the reply briefs are due. But there were a few responses to motions in limine that came early. They were filed by the state early. So we see the defense coming back with an early reply. Again, it's dated the 17th of March, And it states here, comes now, Brian C. Kohberger, buying through his attorneys of record, and hereby replies to the state's opposition to Mr. Kohberger's motion in limine number 11, exclude IGG evidence. That takes us to the bottom of page 1, going into page 2. And the defense here says the state agrees with the outcome of the motion and has agreed not to present any evidence of the IGG process. In its paper, the state says that it can present evidence of a, quote, generic tip, end quote, without revealing the source or substance of the tip. Now, usually, you're going to see replies in other briefings in this case where whoever is filing the motion, the other side is strongly opposing whatever the position was, such as last fall with the filing of the motions to strike the DP. State came back fiercely and opposed all of the different legal grounds that the defense presented, and in the replies to those motions regarding the DP, the defense came back equally strong and then presented their position why the response was wrong. Same thing with the suppression motions and all of the other briefing schedules that you've seen here. So here we see the very rare occasion, while even though the state's paper is called an opposition, they're basically agreeing with the defense. We agree. We're not going to present any evidence of the IGG process at trial, is what the state basically said in their response. Now here it goes on. There's a bit of a caveat here. In its paper, the state says that it can present evidence of, quote, a generic tip without revealing the source or substance of the tip, and then goes on. Mr. Kohberger welcomes this agreement and asks the state to identify the specific witness who will testify in the testimony that will be given. Since this testimony will be sanitized, is how the defense is putting it here, that's their spin on this, for presentation to the jury to avoid the IGG process, it must also not falsely suggest that there was any other evidence or tip that led the state to Mr. Kohberger. Dated 17th day of March 2025, signed Becca Barlow. She's the newest member of the defense team. She was granted pro hoc vice status. That means although she's not licensed to practice law in Idaho, she was granted the opportunity to help to defend Mr. Kohberger in this case by Judge Stephen J. Hippler. So what are your thoughts? Number one, who do you think the state will more likely than not cite to or present to the jury? Who's going to get up on the witness stand when this issue of how did the authorities get to Mr. Kohberger? Who's going to do it? And what other thoughts do you have about what Ms. Barlow is suggesting here? Really interesting twist on this agreement, in my opinion. I look forward to hearing this motion being argued before Judge Stephen J. Hippler, and those very important hearings on all of the in limine motions are coming up on April 9th and 10th. We're going to be hosting a live that day, gavel-to-gavel coverage. I hope that you'll join us here on the YouTube channel. Please go ahead and hit a like. It'll give you a reminder of when the presentation will be live. We will, as always, be focusing on the court records that we always encourage you to do, to look at what is going to actually be presented to this future jury. For a very long time, we, the public, didn't have a lot of this information. It's starting to become a little bit more looser, and we have been provided with some of the evidence and some of the parties' positions has become a little bit more clearer because some of the things that have been under seal for so long, such as photographs of suspect vehicle 1, the text messages between the surviving roommates, the 911 call, amongst other matters. But this will be an interesting couple of days, and I look forward to this motion in limine, and quite frankly, to all of the other motions in limine, deciding what will and will not be presented to the jury and how, as in this case, is so crucial to both of the parties. This will now conclude this episode of the IndieZoNe. Thank you for joining us here today.